articles sometimes will have a lot of great information in there. Not only that, it will connect you to even further information. So if you're not someone that, maybe have read an article before or even pay articles any attention, I tell you, make sure that you read these articles that's connected to student loans. You'll find a lot of great information, okay? This one is on the Forbes website and is wrote by an attorney, Adam Minsky. Always great articles with this attorney. So let's go over this one. This one was published on the 24th of October. And let's go through it and let's talk about it, okay? So what it says is borrowers are contending with an ever-changing landscape of student loan developments with no end in sight to the volatility. Significant developments this month will ultimately affect millions of Americans who have federal student loans. Those who are pursuing eventual student loan forgiveness or affordable payments based on income will be the most impacted. Here's a breakdown of the latest updates for borrowers and how they will affect your student loans in the coming weeks and months. So we know this stuff is coming up soon. Forgiveness resumed for many student loans under court agreement. So if you guys aren't aware, there was a lawsuit, or there is a lawsuit against the Department of Education. It was brought on by the complaint was brought on by the American Federation of Teachers, which is a teachers organization. They work with a lot of nonprofits. They also work with teachers, of course, nurses, other professionals. Go check their website out. The actual president released a book. It's actually a great read. I bought the book, so go check them out. But on Thursday, a federal court formally approved the agreement between the Department of Education and the American Federation of Teachers to resolve an ongoing lawsuit. The AFT has contended that the department has failed to timely process applications for income-driven repayment, or IDR plans for short, which was effectively preventing borrowers from accessing affordable payments as well as public service loan forgiveness. The AFT later expanded its lawsuit, arguing that the department had unlawfully halted student loan forgiveness under several IDR plans. It was setting borrowers up to be hit with a significant tax consequences as federal tax relief is set to expire at the end of 2025. So basically what they are talking about, if you have not seen this agreement, you can just go to Google, or if you go to this article here, you can click this button here where it's got approved an agreement. And actually, this is going to take me to another part of the article. But what you can do, just go to Google, and this is where you can actually get to the entire complaint. So you just type in AFT versus the Department of Education, okay? And the first thing that's going to come up is court listener right here. You click there. And this is where you'll be able to see the entirety of the complaint, the whole entire lawsuit, the whole process of it. And the agreement that they're talking about is this agreement that was reached upon between the American Federation of Teachers and the Department of Education. If you click here, hit download PDF, that is where you can read that agreement, okay? All right, let's go back to the article. All right, so the courts on Thursday approved the provisions of the agreement, which the Department and AFT submitted via a joint filing last week. And these are some of the key elements of that agreement. The department will resume granting student loan forgiveness under the IBR plan. The department had paused IBR loan forgiveness earlier this summer. And this is what they wrote on the website. While our systems are updated to accurately count months, and that was according to a statement published on the department's website, the AFT had argued that the pause was unlawful. The department will restart. This is the next thing that they're going to do in the agreement. The department is going to restart granting student loan forgiveness under the ICR and pay-as-you-earn plans. The department had previously halted loan forgiveness under these programs, arguing that this was necessary due to a court ruling imposing an injunction on the SAVE plan, a newer IDR program under the Biden administration. But the AFT had argued that the injunction did not expressly block loan forgiveness under ICR and pay-as-you-earn. Student loan forgiveness under SAVE remains blocked, so borrowers pursuing a discharge will need to switch to IBR, ICR, or pay. So basically what was happening here was the Department of Education. So if you are someone that's enrolled in a SAVE plan, you know currently there is an injunction against that plan, meaning that the Department of Education is not going to process any type of loan cancellation. They're not even accepting any payments under this particular plan. Borrowers who are enrolled are currently in a forbearance. In order for you to get any credits towards forgiveness, or if you're someone who qualifies for public service loan forgiveness and you're enrolled in a SAVE plan, that means that you would need to come out of that plan and enroll yourself into either income-based ICR or pay-as-you-earn, whichever one of those plans that you qualify for. Because now what the Department of Education had did was they had stopped processing discharges or loan forgiveness under income contingent and pay-as-you-earn, which had nothing to do with the SAVE plan injunction. So that is why the American Federation of Teachers put the complaint in, or filed this lawsuit about the department doing that illegally. So now the department has agreed, the Department of Education has agreed to go ahead and start back, not only processing forgiveness under income-based repayment, but also under ICR and also pay-as-you-earn. So if you're someone that's enrolled in those plans, or if you're in a SAVE plan, and you may have a lower payment under one of those plans, then you can enroll in that plan, especially if you're someone who has forgiveness. You have enough qualifying payments under one of these plans to get your loans forgiven. You want to go ahead and get transferred into one of those plans, okay? The department will not deny borrowers' applications for IBR if they do not have a partial financial hardship. Congress removed the partial financial hardship requirement for IBR in the One Big Beautiful Bill Act, passed in July, expanding access to the program regardless of a borrower's debt to income ratio. But the department has been slow to implement the change. The department shall hold such borrowers' applications in abeyance, or in a pause, so to sense, until the defendants update their systems to allow for proper processing of these applications, says the agreement. So basically what's going to happen, or what was happening with the passing of the One Big Beautiful Bill Act that passed on the 4th of July, one of the provisions in there was that when it comes to income-based repayment, because this is going to be one of the plans that is going to be left over as of 2028, for a borrower to be able to qualify, there had to be a partial financial hardship. That has been removed because of the passing of the One Big Beautiful Bill Act. So those who in the past did not have it, now it's not even a factor anymore. So you can apply, and if you're someone, because there was another thing, if you're someone who had applied on or after the 4th of July 2025 and you were denied, they're actually encouraging you to go ahead and reapply. Okay. All right, because that should not have happened, but because they were saying their systems weren't updated, that's why it was happening. The department will continue processing requests for student loan forgiveness through PSLF Buyback, which allows public service borrowers to try to get certain prior forbearance or deferment periods counted towards PSLF if they make a lump sum payment. Now, if you go back and you look at this lawsuit here, and you start to look at the status reports, because they were releasing status reports every month. Now, we haven't had one because of the government shutdown, but if you go back and you look at the status reports, then what that will show you, and there's one in September, go look at the status report, and it'll actually show you, let me show you really quick. This is the one from September. This will actually show you where they are as far as processing applications. So you can see where they are with deciding the applications, those that are pending, PSLF buybacks that are that have been processed, and the amount that are pending. And this was as of August. So we know that that has gotten a lot bigger since the last time that there was an update. But this is where you can go back and look at that information, okay? Let's go back to the article. All right, for tax purposes, the department will treat the borrower's eligibility date for IDR student loan forgiveness as their discharge date, even if the actual discharge does not occur until 2026. This will allow borrowers who qualify for student loan forgiveness now under IBR, ICR, or PAYE to avoid being issued an IRS Form 1099-C, which will require them to report the amount of canceled debt as income on their federal tax return. Federal tax relief expires at the end of 2025, causing IDR loan forgiveness to return to being taxable again starting in January. Loan forgiveness under PSLF remains tax-free federally. So let's talk about this really quick. So when during COVID time, there was a temporary, I guess we'll say, law provision that was passed. It was called the American Rescue Plan Act. And what that allowed was that for if you have your loans canceled by the 31st of December 2025, that means that you would not have to worry about paying taxes on it. Usually what happens is if your loans are discharged on the federal side, you would be issued a 1099-C, meaning you would have to report that discharge amount to the IRS as income. So what they're saying is, because we see that there's a huge backlog with the Department of Education and processing applications, loan forgiveness, everything, what they're saying is that the date that you meet those qualifying payments, depending on which one of these plans you're in, IBR, ICR, PAYE, meaning you've made either those 240 or those 300 qualifying payments, the date that you make that qualifying payment is the date that will count as your discharge date, even if the Department of Education doesn't get to actually processing it until sometime in 2026. And they're doing that so that you're not hit with that tax bill for 2025 because of that debt being canceled into 2026, okay? The department also agreed to file monthly status reports detailing its progress in processing IDR applications and granting student loan forgiveness under IBR, ICR, PAYE, and PSLF. Those status filings are expected to begin after the government shutdown concludes. So we know that we have some more status report, and they have actually, when you go back and read the agreement here, it'll tell you what all is going to be in those status reports. And there's going to be like 6 of them that they'll be continuing once the government shutdown is over, okay? All right, let's get down to the next thing. Rulemaking will change options for student loans. Let's start there.